Good morning, everyone. Welcome to the Judicial Proceedings Committee. Today is Friday, March 15th. We're going to work off of voting list number 13, and we're going to start off with Senate Bill 100, and that is Jamie. Senate Bill 100.
Senate Bill 100 establishes the offense of organized retail theft of property with an aggregate value exceeding $1,500. A violation of this prohibition is a felony punishable by imprisonment for up to 5 years and/or a $5,000 maximum fine. A person who violates this prohibition must restore the property to the owner, or if unable to restore the property to the owner, pay the owner the full value of the property. A conviction for organized retail theft merges into a conviction under the general theft statute for the purposes of sentencing, where the two convictions arise from the same acts or transactions. The bill also clarifies the venue for prosecution of a case involving multiple thefts in multiple counties committed by the same person under one scheme or continuing course of conduct. There are no amendments. However, we did receive a request for Senator James to be added as a co-sponsor.
Sorry.
Yeah, I got a call from Delegate Tolles about an amendment to kind of align this bill with the House bill. Yesterday.
Did you get any amendments, or we'll check? Do you have any idea what it does? Yeah.
So we're supposed to send it over. I'll share it with everybody, and if I offered as a friendly floor amendment, if everybody agrees.
No, oh wait. 100, yeah.
You got it?
Okay. I mean, maybe.
Do you want? I'm texting with the retailers. They want it.
Yeah, the retailers actually brought it up too.
Yeah.
What your problem is under that umbrella of theft. You have car theft, you have bad check collection, you have a whole bunch of things. So this would separate out organized retail crime and professional theft.
It would apply to, I'm just reviewing the amendment right now, but it would apply to a conviction or probation before judgment for not only theft, but also burglary and robbery, and use of a firearm in commission of a crime of violence or felony.
While engaged in retail?
No, not necessarily. I mean, the idea is that if a person is convicted or receives probation before judgment for any of those offenses, the state's attorney would make a request to the court, and the court would make a finding based on the evidence produced at trial as to whether the crime is organized retail theft. I guess from a technical perspective, the only thing that I can kind of think of, and this is just coming to it, reading it kind of cold here, is that those dispositions may not be reached exclusively because you go to trial. You could have a plea, you probably would have a plea. So yeah, that's just my only observation on that. Yeah.
Was entered in there because a lot of times now we're finding that it's becoming very aggressive. People are wielding weapons. I'm so sorry. Yeah. The thought process behind that was that a lot of theft now, folks will have weapons on them. It turns into armed robbery. So we didn't want the stat to just fall under armed robbery. We also still wanted to authentically capture it under organized retail crime because that's why the person originally went in there in the first place. So that's why that was added in there. And then you have it's lifted from it was supposed to be lifted from the domestic violence statute and the same evidentiary standard that you're using for domestic violence. So that's where we lifted that from.
While we're waiting for the amendment to be printed out, I think I mentioned this during the hearing, but the chairman and I were at an event. I parked at a CVS across the street from the event. Coincidentally, the event was about youth justice, juvenile justice. And then I went across the street to grab my car, realized I needed to grab something for my wife. So I went into the CVS to grab milk before I went home from the event. And as I was walking in, there was a group of teenagers who were walking in with me. And it was clear that something was about to go down. And that's what happened. When organized retail theft happens, it is a very scary thing. It's scary for the people inside the store. It's scary for the employees. And you never know what people will do. You don't know if there's a civilian in there who's going to try to take the law into their own hands. You don't know if the people who are committing the organized retail theft are intending to use violence to do so, or are just going to walk out. And so I kind of froze, but I was kind of tracking what was happening. And you knew it was organized as opposed to just people essentially stealing stuff for themselves for their own, because they went straight for the laundry products. And these are teenagers. I can't imagine they're utilizing laundry products frequently. And that's what, and so they kind of grabbed all the laundry products. As they were going out, one of the guys was, decided he wanted a candy bar. So then they all went and grabbed, that was definitely for themselves, and then went out. And this is how you also know it was organized. There was a car there waiting for them, but they didn't use the car as an escape vehicle. So they loaded the stuff into the car sped off. They then had nothing on them. So if they were stopped, they wouldn't have any stolen items on them. And then they walked to the Tacoma metro station No, they did not have the stolen items. There was a vehicle waiting to take the stolen items, but not them. And so it was to separate them from the stolen items so that they wouldn't be stopped with it. Anyways, so it was very well organized. It was also very scary for me, who was part of it. So anyway, I just wanted people to hear that story as we waited for the amendments.
The funny part about that is that, so I came out 10 minutes after Senator Walsh right here did, and I parked on the other side of the CVS. And I saw the tail end of it. Everyone was kind of darting out in the garage. Oh, it was there? Yeah, it was right there. I was on the other side. I was watching. I knew it happened. I didn't see it inside. I saw him coming out outside. And I was like, all right. Oh, sorry to hear that. Sorry to hear that.
I was on Instagram the other day, and I end up seeing it's a California mom who's the ringleader behind $8 million retail theft ring that had over 200 Ultra stores. It's literally it's somebody, it's this mom living in suburbia. Her and her husband got all of these folks coming together to do all of these retail theft. And it's a national retail theft ring being done by somebody hiding out in suburbia. Blaming all of the kids in the neighborhoods.
Right, exactly.
Just to stand with what Senator Wallstriker said, I think that usually I'm one, when you talk about felonies and moving something to a felony, I usually very, very leery about that. But in this case, for something that is becoming life-threatening, back in my day, shoplifting was walking into a store and maybe taking a pair of sunglasses and hoping you get away with it. It's become organized crime. We can't blame our retailers for one, and that in some of our areas, they're moving their stores because they're losing that much, that they're having to shut down and move. And in some of those areas, they are left with almost nothing. It's incumbent upon us to stand with our retailers when it comes to this, and to do everything that we can to get a handle on this. And so I support it 100%.
Excellent. Well, thanks. Everyone's got the amendment now, so take a moment to read over it. While that's happening, council, I mean, so I remember during the hearing, we had the whole concept of, joinder and having multiple different defendants in different kind of jurisdictions. And could you just tell us what joinder is, talk about the concept, and is that issue at play here under this bill?
Right. So during the bill hearing, I think OPD had raised the issue of potential prejudice to defendants who are joining multiple cases into a single trial could potentially prejudice a defendant. I'd actually reached out to the Attorney General's office after that bill hearing just to see whether or not there was a potential constitutional issue with doing that. And the information that I received was that it looks to be that the provisions of the statute or the bill would be consistent with current law with respect to joinder of charges and offenses under existing Maryland Rule 4-253 and common law joinder principles in Maryland. The gentleman from the Attorney General's office had indicated that the bill did not appear to seek to remove the existing discretion of a court in the joinder or severance of offenses, and pointed out that, this was a case quote, that under Rule 4-253B, upon the motion of a party, a trial court may join separate but related offenses in a trial of a single defendant where the defendant has been charged with 2 or more charging documents, and that the rule is based on a policy favoring judicial economy, and its purpose is to save time and expense of separate trials under the circumstances named in the rule. If the trial court, in the exercise of its sound discretion, deems a joint trial meet and proper, if it goes on to say that if it appears that any party will be prejudiced by a joinder of trial of counts, charging documents, or defendants, the court may, on its own initiative or on motion of any party, order separate trials or counts, charging documents, or defendants, or grant any other relief as justice requires. So there's an analysis that a court would take in that scenario, and the OAG's opinion was that really wouldn't change in this scenario if it appeared that there was going to be prejudice, the court would have discretion to sever the trials.
All right, back onto the amendment. Any questions on the amendment? Motion's been moved. It's been seconded. Is everyone okay adopting the amendment? All right, now the bill is before you as amended. Further discussion. It's been a motion for favorable and seconded. Is everyone okay being reported in the affirmative, or do we need a roll call? All right, one absent.
Yep.
All right, Senate Bill 100 passes 10 with 1 absent with amendment. Smart, we're going to go to Senate Bill 139.
Senate Bill 139 generally exempts an obligor whose individual income for the current year is at or below 250% of the federal poverty guidelines from provisions requiring the Motor Vehicle Administration to suspend the obligor's license or privilege to drive in the state if the obligor is out of compliance with the child support order and specified conditions are met. However, this exemption does not apply if the obligor has been judicially determined to be voluntary impoverished under state law. There is an amendment from the sponsor. That's Amendment 693-621/1. And that amendment is to add a preamble to the bill. There's another amendment, Amendment 943-024/1. And that amendment removes provisions that extends from 60 to 120 days, the period during which the holder of a non-commercial license may be out of compliance with the child support order before the Child Support Administration notifies MBA to begin the process to suspend the obligor's license. That provision is removed because the committee passed Senate Bill 174 this week, which had the exact same provision. And the amendment further moves the requirements under the bill to a different subsection, also to not conflict with Senate Bill 174. But other than that, it's really a technical amendment.
Yeah, I get amendment number 2. Let's talk about this first amendment, the sponsor amendment.
Yes.
What was the rationale for the preamble? Just curious.
Seems like just to kind of declare that the Department of Human Services is trying to improve processes surrounding suspension of the obligor's license and trying to make it easier and holistic. And so seems just like a statement of legislative intent.
So do I. I suggest we just adopt a technical amendment. So that's amendment 94302/1. I'd like to move that amendment. Second. Okay. Is everyone okay adopting that amendment? Now the bill's before you amended. I'm with you on this one, Senator West. I'm not. It's obviously not going to affect the bill at all. So, yeah. Okay. Further discussion on the bill. All right. Senate Bill 139 with amendment passes unanimously. All right, let's go on to Josh, Senate Bill 740. Also, if you could explain the amendments and how it aligns with your driver's license as well, and how there's the parallel penalty scheme.
Senate Bill 740 authorizes a court to prohibit a person from operating a vessel on the waters of the state for up to 2 years instead of at most 1 year under existing law, if the person is convicted of operating or attempting to operate a vessel while under the influence of alcohol. If the violation resulted in the death of another, the court may prohibit the person upon conviction for up to 5 years. The bill also requires the Department of Natural Resources to establish and maintain a database of persons prohibited from operating a vessel on the waters of the state on or before or on or after October 1, 2025. So there is an amendment in your packet from the sponsor, which is number 303326/1. The amendment would add a criminal prohibition on a person who operates a vehicle, a vessel on the waters of the state while prohibited under the provisions of the bill. The offense would be a misdemeanor, which would be punishable by 1 year or $1,000 fine for a first offense, 2 years and a $2,000 fine for a second offense, and 3 years or $3,000 fine for a third offense. So that is somewhat similar to the penalties for driving while your driver's license is suspended, although that doesn't have a third or subsequent offense, but it's similar in that the first offense would have a maximum of 1 year and $1,000, and a second, a maximum of 2 years or $2,000. There are a couple of proposed, or I think we should adopt that amendment, and then there may be
Yeah,
further
let's talk
amendments to
about
that
it.
amendment.
Just, so this mirrors, again, like you're operating a motor vehicle with a suspended license, except for the third. What was the, just the reasoning for the third and offense offered?
I don't think it came up at the hearing, so I don't know.
I don't know anything about this, but how often does this happen? Do people a lot? I mean, they're caught a lot second time? I don't.
I don't think I have those numbers. I think part of the issue that was raised at the bill hearing is that there's currently no way of tracking who's prohibited under this kind of provision, so it may not be possible. I mean, if you're on probation and a condition of probation is not operating a vessel, it would be a violation of probation, and you could have some punishment through that means, but otherwise, I think the reason the bill creates a database is because there's currently no way of enforcing that.
No, I like the database thing. And then just for clarification, we talked about this before, but so if your license is suspended for driving, this does not apply for boating.
That's part of the further amendments I
Okay,
can talk about.
because right now it does.
Currently, the way the amendment works is for this new offense of boating while you're prohibited. It does specify that if you've previously been convicted of a DUI in a vehicle, that would be considered a prior conviction for the purposes of this operating a vessel while prohibited. I think a further amendment may be to strike that language.
This is a policy choice. I think I would say boating, car driving, but, and they shouldn't connect, but that's my preference personally, but I don't, it's up to you guys. What do you think?
The judge have access. Judge know what the person has done in the past. I'm just saying, just think.
All right, so what about so then if that's we'll talk about that in the next minute, but what about the third? What do you all think about the third? Or subsequent? It's there, it does not mirror what is there for the auto suspension. It's up to you all.
In section E, there's there's first offense, second offense, third offense with the same fines. In there, I'm on top of page 3 now.
That is for the actual boating DUI offense. I think the new offense is kind of the boating once you've already been convicted of boating DUI, you can then be prohibited from operating a vessel. And the new offense would be that you operate the vessel while prohibited. So the penalties you're referring to are the actual boating DUI penalties.
I don't have a strong view on this one way or the other.
Say what?
I don't have a strong view one way or the other. It's up to you. Yeah. Instead, you could say for a second or any subsequent offense shall be 2,000 and stop at that and stop there. Drunk boating?
Live in a boating community and go out a lot. I do not know this for sure. I'm only suspecting that much easier to escape getting caught. And just based on what I used to know, people go out a lot like this and, much more than in cars. There's just this may change that mindset, but there's a very different mindset when you're driving versus boating. Boating's a party time, so on and so forth. So my only guess is that this, because it's very prevalent and culturally they want to start changing this. And yes, it's very likely that people go out a third time because they just haven't gotten caught in the past. Now, going forward, we may be changing the culture here and ultimately people be more compliant and more serious about it. So I'm not suggesting we keep it or not. I'm just telling you what I think, what drove it to some extent. It's not the pontoon boats.
The pontoon hanging out.
It's the speedboats. It's
The speedboats are the terrible. I mean,
You can't really.
you can only do so much damage on a pontoon boat. Just keep, let's go, motion to adopt the, yeah, let's adopt that, then we can, yeah. Is everyone okay adopting the amendment? Okay. Second amendment.
So the one further amendment to the amendment that we discussed is if you turn to the second to last page, the unnumbered page on the reprint, this is just that paragraph 2 there, which says, for the purpose of determining subsequent offender penalties for a violation of the section, a prior conviction under subsection A or 21-902 of the transportation article shall be considered a prior conviction. That would be struck. So that's what was discussed about not making a vehicle DUI a prior conviction for this new offense. And then there's kind of a further technical amendment if you turn to the page before that, so page 4 of 5 of the reprint. On lines 25 to 30, there is this application language, which is part of the boating DUI statute, clarifying which vessels the statute applies to. We would simply be copying that language and putting it in the new provision just to make it clear that kind of the same world of vessels that boating DUI applies to is what this new offense also applies to.
Yes, a second. Is everyone okay adopting? All right, excellent. All right, we'll give you a second to catch up. Finally, Josh, so just the definition of a vessel, it's, we're not talking about inner tubes or, you're hanging out on your banana boat on the lake. You're gonna get arrested for, yeah, go ahead.
Because of the language we copied into the provision, it's any vessel that has to be registered with DNR. So that is not like a very small tube or something like that. And
A log.
and this is also
You gotta ask. You've got to ask.
also for clarity, all of the boating DUI stuff applies to the waters of the state. So not, the pool in your backyard. So.
Let's give top line with the amendment, the bill before you, since we don't have the interlineated copy of all the amendments adopted. Can you just describe what the bill does now?
So the bill, first of all, extends the amount of time for which a court can prohibit a person who's been convicted of boating DUI from being allowed to operate a vessel registered with DNR on the waters of the state. So the current law is up to 1 year. With the bill, it would be up to 2 years or 5 years if the boating DUI violation caused the death of another. It also requires DNR to establish this database of people who are prohibited, and it creates the new offense of operating a vessel while you're prohibited as a result of a boating DUI conviction. with the penalties that have been discussed.
No. Maybe there's a reason I'm not aware of. It seems to me that it's the same as it is with DUI. When someone is killed, we just give the minimum amount of time. And you have 5 years in there if someone is killed, and that's the maximum we can go.
The 5 years is for the time that they can be prohibited from operating a vessel. So if there's an accident, a DUI, and someone is killed, there's probably other criminal offenses that could be brought in for that. Yeah.
What happens criminally if someone is killed under current law?
So you could have the boating DUI offense, but that would also be potentially a manslaughter by
Okay.
vehicle or vessel, which is a separate criminal offense.
Okay, good. Thank you.
Is it 10? We may have raised it in one of the bills we had. Homicide. So it, Section 2-504 of the criminal article, homicide by motor vehicle or vessel while impaired by alcohol. And I believe, I'd have to double check. I believe the committee actually has moved a bill this session that increases these penalties. But under current law, it's 3 years or a $5,000 fine, or for a subsequent offender, 5 years or a $10,000 fine. Yeah.
Bill? As amended. Motions were favorable? Is everyone okay being recorded in the affirmative? Senate Bill 740 with amendments passes unanimously. Okay, we're gonna go on to Senate Bill 944.
So Senate Bill 944, JPR is secondary on this bill. The Senate Finance Committee voted the bill out favorable with amendments. As amended by the Finance Committee, Senate Bill 944 repeals a provision of the criminal law article prohibiting a person from selling or offering for sale a non-latex condom by means of a vending machine or other automatic device. Current law provides that violators of that provision are guilty of a misdemeanor and subject to a fine not exceeding $1,000 for each violation. A violation is considered each vending machine or other automatic device. Rather, the amended bill prohibits a person from selling or offering for sale a natural membrane condom by means of a vending machine or other automatic device. This prohibition is added to the Health General article and would be subject to the penalties under
I have a definitional question, Jamie.
21-1215 of the Health General article. Sure.
No, but I do have a definitional question, Jamie. All right. No, I'm not gonna do that to you. Don't worry. All right. Yeah, go ahead. Senator Kelly.
This committee was secondary on this bill. But I think sorry, this is actually a really good public health bill. Prince George's County Health Department came to the table and was really supportive of this. It passed out of finance unanimously with the amendments. Just so you all are aware of sort of what we're talking about here. The bill does two things. The first thing it does is it basically changes the Nurse Practice Act, because in our public health departments right now, everybody who works in the health department, whether they're a doctor or a receptionist or a janitor, can hand you a condom, but a nurse can't because of some rules in the Nurse Practice Act. So this changes that, so that if you have a condom or other over-the-counter birth control, the nurses can hand that to you without being in violation of the Nurse Practice Act, which is really important for the health departments. It doesn't require that they do that, it just allows them. And then the second thing it does is it addresses the we're the only state in the nation that has this really old-timey criminal penalties in the criminal law article that make it illegal to sell certain condoms in vending machines. This moves that from the criminal article. It leaves, you'll see in the fiscal note that there's some conversation about schools. All of that has been taken out. It doesn't address anything that could be distributed in schools. It just says, it modernizes it. When we put those penalties in place, they wanted to make sure that those lambskin membrane condoms, which are not good for preventing disease or pregnancy, were not in vending machines because that's contrary to public health. It keeps that provision, but allows for the newer non-latex condoms that are good for people with latex allergies to be allowed in those vending machines, and just moves all of that enforcement into Health General, into the health rules instead of the criminal article. So that's all it does. And it was unanimous, including all of the Republicans in finance, and unanimous on the House side.
Jamie, can you give me I want to know, like, can you give me the rundown of the differences of like the different natural membrane versus what that would entail?
He did what I wouldn't.
Is there?
All right.
Thank you, Jamie.
So just so that I'm understanding what I think the explanation just was, 10-105 under the criminal laws being moved under somewhere within the health general article?
Right, so it's not technically being moved, because what's prohibited now under the criminal law article is the sale of non-latex condoms in vending machines. So it would be permissible to have a vending machine like in a restroom or somewhere else that dispensed latex condoms. But what's currently prohibited is if it is dispensing non-latex condoms. My understanding from the bill sponsor, and also talking with committee counsel and finance, is that since the original language of that statute was passed, condoms that are not made of latex but are synthetic nonetheless, and just as effective as latex condoms at preventing pregnancy and the spread of STDs, are available. So you could get condoms from that or with that material, and they would be just as effective. What the concern seems to be is the natural membrane products. I think the example was given of lambskin condoms, and my understanding is that that is a permeable membrane. It allows the it's not very effective at preventing the spread of disease or preventing pregnancy. So that's what would be banned under the very similar provision that's being put into the Health General article.
And the committee, because this may come back in a subsequent bill in future years. We're the only state that has this criminal article penalties about condoms and vending machines under any circumstances. So it was part of a compromise from the 80s to pass to allow them in vending machines. So, sometimes our compromises we need to be cleaned up after a few decades.
So why don't we just remove it for all? I mean, look, I know it's because they don't have like redeeming health purpose. There's no real health benefit, or like it's not going to stop STDs, or it's not going to stop you from getting pregnant with the lambskin condoms or whatever. But why are we criminal? Why don't we just move that to, I mean, that's maybe another bill. I don't want to mess this up, but
I think there'll be another bill to do exactly what you're
Okay.
suggesting next year.
yeah, this seems dumb, man.
Mhm.
Yeah. That's what I'm saying. And college, I mean, too, like college dorms, like this is dumb. All right.
The neon ones?
Including.
I don't know what they are, Andy.
Let's move the amendment. Can we move the amendment? Is everyone okay? Adopting it?
Just a technical,
Yeah, hold on. Go ahead. Yeah.
flagged with committee counsel over in finance, and he indicated it shouldn't be a problem. The purpose paragraph just needs a technical fix from what you see in the reprint that's in your voting packet. Just wanted to
All
flag
right,
that.
so wait, real quick then, so the amendments already are incorporated from the bill that passed out of finance, or do we need to adopt these amendments too?
Well, yeah, I think the appropriate vote would had adopted.
Okay.
Yeah.
Motions for, all right, everyone's okay with that. And then do we need to adopt the second technical one?
No.
All right, it's already incorporated.
Technical.
Got it. You can do that.
Yep.
Now, sorry, go ahead, Senator Kelly.
I thank Jamie for being really thorough with this and catching some concerns that were not noticed by the House side, which is assigned to the Health Committee or Finance. So thank you very much. Appreciate it.
JPR strong, there you go. All right. So now the bill's before you as amended, motions for favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Awesome. Senate Bill 944 with amendment passes unanimously. All right, Senator Benson, Senate Bill 725 was withdrawn, so the motions for an unfavorable withdrawn. At 725 has been withdrawn. Motions for unfavorable withdrawn, it's been seconded. Is everyone okay being reported in the affirmative of that? All right, Senate Bill 551.
Senate Bill 551 makes various changes to procedures related to the release of a person committed to the Maryland Department of Health after being found not criminally responsible. The bill does a number of things. It first establishes that the Maryland rules governing discovery in the circuit court apply to a proceeding to determine eligibility for conditional release or discharge. It requires that a court and the Maryland Department of Health promptly inform a committed person's counsel of record when they receive a report that a committed person violated a condition of release or violated conditional release, respectively. The bill requires a court, on request by any party, to hold a hearing after an application is made for a change in the conditional release of a committed person to determine whether the applicant has satisfied the requirements for release. The bill establishes that a preponderance of the evidence standard applies to an applicant in change of conditional release proceedings. And finally clarifies that a court may extend a conditional release by up to 5 years and authorizes a court to shorten or terminate the conditional release. There are no written amendments, although in speaking with the sponsor, he's indicated that the bill should be clarified to provide that the rules of discovery that will be used will be the circuit court civil rules of discovery.
So there, that addresses part of the judiciary's concern, right?
Exactly.
Okay, just so then the second part of their, just want to make sure we speak to this, make sure it covers it. So the second part of the bill, this is from the judiciary's opposition. The second part of the bill would require the court to hold a hearing if requested by any party, including self-represented litigants, and permit additional hearings. And then they say this is unworkable. Does, are we?
Right.
Yeah. Can you speak to help us?
So based on, thank you for bringing this bill to a vote. Based on speaking with the state's attorneys who are in support of this bill and also the attorneys that work for our mental health division, it's extremely rare for a self-represented individual to actually be filing motions in these cases. I spoke with Miss Sparta, who's a state's attorney in the city, and she's been practicing for 13 years and has never seen it. And additionally, there are still procedures in place that limit the amount of filing total. So it may result, the estimate is that it may result in 1 hearing per year per person on conditional release, which is not a significant increase to what was previously in place. And just as to the third point from the judiciary, the reason that we propose this in statute as opposed to the rules is that the procedure is already codified in this statute. And so it would be unnecessarily confusing to try and adopt rules that don't already address this procedure to try and match them to the statute that does already address this procedure and is already in place.
Let's move the amendment.
Right.
All right. Is everyone okay with that? Now the bill's before you as amended. Further discussion. It's been a motion for a favorable. It's been seconded. Everyone's okay being recorded in the affirmative. Senate Bill 551 with amendment passes unanimously. Senate Bill 943.
Senate Bill 943 establishes a statewide authorization for local jurisdictions to use bus obstruction monitoring systems to enforce the prohibition against driving a motor vehicle in a dedicated bus lane. As a result, the current statutory provisions governing bus lane monitoring systems in Baltimore City are renamed and expanded to incorporate all local jurisdictions in the state. In addition, the bill establishes new prohibitions against standing or parking in a bus lane and establishes the work group on curb space management staffed by the Department of Transportation. The bill will terminate, the work group would terminate on June 30th, 2026. There is an amendment in your packet. It's number 463927/1. This is just a technical amendment that corrects cross references which are being made obsolete by the bill.
Sorry, just to refresh the committee's memory, we heard this bill a few weeks ago. This is the legislation that expands what's already happening in Baltimore statewide. It's just authorizing counties to do this, and it's strongly supported by the National Federation of the Blind, among others. So just wanted to refresh your memory, and I would love to move favorable on the amendments, which are technical.
So. All right, everybody okay? All right, now the bill is before you as amended. Further discussion?
I just have a question, Mr. Chair, if we figured out any better language than, because the concern is that if somebody needed to drop somebody off at the curb, that if they crossed over into this and a bus pulled up behind them while they were dropping somebody off safely at the curb, the way this bill's written is that you could be written a violation for it. And to not be written a violation, you would have to actually drop off your person while in the furthest right lane that is not a bus lane, which means you're in the road. So do we have is there any language, was there any consideration giving,
Group, right? I mean, we're expecting curb management work group recommendations, right?
I mean, did I miss? Is it only a work group now? Or is
No,
it,
so
yeah, so we're still looking to move legislation without having a solution in place for a potential problem. I mean, it'd be simple enough to put an exclusion in there except for the dropping off or picking up someone.
Can you talk about the review process when a citation is issued?
I mean, the citation does have to be reviewed by, typically it would be a law enforcement officer in a jurisdiction that has a police department, and they would make the determination on whether a citation should be mailed.
But the point is that you're still, if you go by the letter of the law versus the spirit of the law, I understand the design of this, but the letter of it says they would get a citation. So
Yeah, I mean, it is ultimately at the discretion of the officer or other employee who reviews the video to whether a citation should be issued. I mean, I would note that in the actual, and this is on page 2 into 3 of the bill, I mean, in the actual prohibition on stopping in a dedicated bus lane, there are carve-outs to that, so that the committee could consider creating additional carve-outs to the underlying prohibition there.
In between sessions, again, are we coming back? I mean, I'm not opposed if Senator Folden wants to draft an amendment that is narrowly tailored to address his concern and for us to consider it. I'm not opposed to doing that. I just don't want to hold the bill up before crossover. It's also something we could address after crossover.
says except in circumstances of drop off or pick up to the furthest edge right of the roadway or furthest.
Currently, you see one of those exceptions, item 5 there is a vehicle making a right turn at the next immediate intersection. There's probably some language, a vehicle that is
Dropping off or picking up personnel for a brief stop.
Yeah, stopping, for no time,
Which would have to be differentiated, sorry. My mic, but just differentiated from like loading, because a lot of the,
Correct, yeah.
a
not
lot of the
loading,
culprits
not
here
loading.
are
We're talking-
people unloading giant cases of
Yeah,
water.
Yeah, we're not talking about
retail.
loading or unloading a vehicle. We're talking about
Yeah, I mean, the exceptions are those 6 exceptions that you see from the bottom of page 2 into page 3. That's the prohibition on stopping in a dedicated bus lane.
you put passengers like Mary Delaney said, if you,
Yeah, making a,
then it's not, you're not making it, you know, like she's saying, loading or unloading of cargo. We're talking about. the
might,
actual
yeah, correct.
Yeah, no.
Something to the effect of a vehicle stopping for the sole purpose of dropping off or picking up a passenger
Correct.
or passengers, sort of stopping, making a brief stop or a stop. If we say stop solely for the purpose of
Transitory stop,
transitory,
is that, for the purpose of dropping off, I don't know if that goes well with it, for the purpose of dropping off or picking up passengers.
What is that in the code that we're transit?
Yeah.
so this would be a new exception to the general prohibition, a vehicle making a transitory stop for the sole purpose of dropping off or picking up passengers.
Yes,
Is that-
perfect.
For you as amended
With that.
with that amendment incorporated. So hold on, just make Sandy's got caught up. Hold on.
Thank you.
All right, so we've adopted both. Right, we're good?
Yep.
All right, motions were favorable, it's been seconded. Is everyone okay being recorded in the affirmative? Okay, great. So, oh, you're good?
Yeah, just.
Okay.
Facial recognition.
Understood. Okay. All right, Senate Bill 943 with amendments passes unanimously. We're gonna give Jamie a little bit more time here. We're gonna go with Shamari,
I can have it.
but we're gonna just get the attorney thing out.
Okay.
Yeah. And then you got amendments for how many of her bills?
2 of them right now.
Okay. All right, so we're gonna go. Sure.
So I'm just being advised by some of my reviewers that brief may be a better word than transitory here, if the committee is okay with that.
I would say, why don't we just say like, the intent is to capture this, that way you have three numbers. Yeah.
Yeah, I think the concern was transitory may simply mean not permanent, so it doesn't necessarily have the same connotation as brief, so.
How brief?
Yes.
What's considered brief then?
Brief is less than transitory, but more than something else. I don't know.
I mean, transitory means not lasting.
We are still using this for the sole purpose of picking up or dropping off. So if you're extending the stop to do something else,
Transitory means not lasting, enduring, permanent or eternal, and then lasting only a short time, brief or short-lived, temporary. That's a dictionary definition of transitory, but okay. Whatever they say, we'll do what they say.
Whatever word, it should just clarify that it's for the sole purpose of that.
yes. So
And no longer than required, like no more force than necessary, no more time than necessary, right?
So we do have for the sole purpose of picking up or dropping off. So if you're extending it to do anything
So,
else.
like, you
that would
can't
take you
stop-
out of it.
Drop off and get your drugs at the same time, you gotta just get the stop. Yeah.
All right, so we can adopt it, give them a little bit of flexibility to do whatever. Intent is clear, is that good? Okay. All right, so that it's Senate Bill 943 with amendment passes unanimously. All right, we're gonna go to Shamari with Senate Bill 889, and then we'll go to Senator Ricardo.
Senate Bill 889 authorizes a civil enforcement action brought by the Office of the Attorney General to enforce the provisions of the Maryland Antitrust Act to be instituted at any time. The bill also specifies that a civil enforcement action brought by OAG is exempt from the 1-year statute of limitations under section 5-107 of the Courts and Judicial Proceedings article for prosecutions or suits for a fine, penalty, or forfeiture. There is an amendment in your packet. That amendment is 683-324/1. And that amendment removes the provision that allows the Attorney General to commence an antitrust action at any time and leaves the statutory statute of limitation at 4 years. And the amendment further makes the statute of limitations for a civil action for a statutory penalty brought by the Attorney General to 12 years instead of unlimited.
Senator West, I know you had a very good discussion during the hearing, so I'd like you to speak on your thoughts.
Yeah, thank you, Mr. Chair. So, yeah, I think we have statute of limitations for a reason. I do not like to eliminate statute of limitations. The general statute is 3 years. We have statutes as short as 1 year and as long as 12 years. So I ran into Steve Sakamoto Wangle, outside one afternoon, and we talked about this, and I expressed my view, and he's now come back and suggested this amendment, which limits the statute of limitations to 12 years, which is something I can accept.
I'd like to move the amendment and then discuss the bill as amended. Seconded. Is everyone okay adopting the amendment? Okay, senators, we've adopted the amendment. The bill's amended before you, but Senator Sidnor has a question.
Right, so I mean, if we're using 12 years, we're treating this as if it's some sort of a sealed document or a sealed case. Yep.
I think for their purposes, it definitely, I mean, it's a longer period of time, but it's not indefinite. And so there's like a balance. There's some sort of a balancing act going on. Gives them a time.
And I don't remember this hearing, so I may not have been here for this hearing. So was 3 years an issue? That was an issue?
No, my point was I'm very opposed to simply eliminating statutes of limitations. So I think we talked either in the hearing or outside the hearing about the various statutes that the state already is using in various situations, and the highest one is 12.
Gotcha.
And I said I could go with 12. And so that's what they've agreed to.
Right, and 4 years must have been because I'm looking now, and 4 years was the stricken language. So that must have been an issue with them being able to bring a case in that. Gotcha. Okay, that's all I was trying to figure out. Thank you.
So I think I was on a timeout on this day. So can so in the original bill, it takes away the 4 years, and then in the amendment, it puts it back in. Is that what I'm? Yeah, I know.
And then, so then, you know, there's a strong conversation and then further discussion. So now he's putting it back to, he's putting it to 12. And I think it bumps up from, what was the initial 4? Was it 1?
It was 1.
It was 1. So.
And can I ask where the 12 came from? Because. Yeah, but why are we? Oh, they don't have enough time. Maybe they're doing too many things that they don't need to be done.
I'm sure we could give them more pens. They'd like that. We give them
Yeah,
more pens
yeah.
and some more.
Oh, we
some
keep
more
giving
budget
and
money. I
giving,
don't
and
know.
now they can't. They don't have enough time. Wow. You only see my shocked face. So they don't have enough time. So we need to go from a year to 12 years is what we're doing.
And it's a compromise.
That's
Yeah.
They wanted no limitation.
Yeah, I know that, but why are we, so the idea of compromise is if I want to compromise, if I want a longer term, I'll come in and I'll offer. I don't want to ever have a statute of limitations. Oh, you're going to give me 12 years? Okay, that's my compromise. That's not a compromise. You went from 1 to 12. A compromise would be if you're going to move it, move it to like 5. What instances are they needing time more beyond 5 years to go after to be able to do this? This is just, again, we're just given a lot of latitude. Here we go again. Attorney General's office, we're just going to give them carte blanche authority to do whatever on these civil actions, and it just is like, what is the impetus behind this?
So one other feature of the testimony that I thought was good that I didn't know this, but is that, and Shamara, you got to help me along with this, but that initially, so the way that the statute, which is adopted, I think it dates back to the 1700s or something like that. Right. But that for administrative proceedings, there's no statute of limitations for this. for the Attorney General, right? Is that right? And so in practice, it actually doesn't, the same standard is adopted for the civil proceedings. And this is the way it's kind of playing out now anyway, but there's a little bit of the fact that the statute isn't clear, lends a specter of kind of uncertainty for their practice, even though that's how this is operating right now, is what their testimony was. So can you help? Is that right? I mean,
Yeah, so-
I'm just kind of going off their memory because I remember, I forget the
there's-
gentleman's name, but I thought he provided a very good presentation.
There was case law that held that the statute of limitations for instituting administrative enforcement proceedings is unlimited. There's no case law directly on point for the civil side in a court of law. But the way the Attorney General's office has been operating, you know, they generally go through administrative proceedings before filing for civil penalties in court. And so just the way they've been operating has been as if the statute of limitations is unlimited, though in statute it says 1 year.
I guess the point being is that this isn't actually a radical departure from how things are actually functioning at the moment. Go ahead.
So what are some of the acts that they can bring cases against folks under this new law? I mean, removing the statute of limitations. Like, what are some of the issues they can bring? You know, this is what civil suits.
More like competition. Can you kind of go through the list of what's covered?
I'm pulling up the code section.
Am I correct?
Only reason I asked is somebody brought up to my attention, somebody could sue you for something 20 years ago under this.
My concern is that even 12 years. You know, when you're talking about someone that's an adult, which is really the only time you can start to even be sued, we're making it basically 1/5 of the remaining, at best, if not a quarter, of what is the average life expectancy of someone. So we're making 1/4 of their life remaining that they would be liable. And that's if they got it at 18. If you go into civil action in your 30s, you're gonna put them up to almost 50 that they would be liable for this. And you know, and when the Maryland Supreme Court recognizes the statute of limitations strike a balance, and primarily to assure the fairness to the defendants in the theory that claims asserted after evidence is gone, memories have faded and witnesses disappear. Like, and it's so to allow this is just unjust. You know, it's not appropriate that we're allowing people that usually aren't civilly liable until they've established themselves or business owners, and then they're going to be open for almost over what would be normally half of someone's retirement.
But again, this is a session of accountability. I mean, these are, the Attorney General is not just willy-nilly going out suing folks. So these are folk who have committed some sort of violation of our civil law.
Can they show documented cases where they were not able to go after somebody under the current provisions in law? They can't.
And don't get me wrong, I agree with Senator West. I don't think we should just get rid of statute of limitations, but
even at 12 years, Senator, even at 12 years, that's over a quarter of what an adult person has left in their life usually, that they would be liable for this. That's a bit extreme for a, you know, when we're talking about fundamental fairness.
So the change we're making from 1 to 12, that deals with any suit for a fine, penalty, or forfeiture. Typically, the Attorney General is involved in consumer protection actions, antitrust actions, civil rights actions. And so any place where they have statutory authority to file a civil action, that's where the statute of limitations would apply, except for antitrust, which is separate at 4.
Like an individual versus individual. This is purely the Attorney General.
This is just the Attorney General. Everyone else would still be at 1 year.
Like, what's good for one? Good for all. Is this, and my other question is, how does this affect what was just rammed through yesterday with him being able to go and legally seek action against the gun manufacturers anywhere in the country? Is that a part of this too? That he's now available up to 12 years to go after him? That's a problem. That's a problem.
And so this is from the Attorney General's. There's the reason they're asking for the 12 years is that there's often delays in investigations, delays in producing documents for these large enforcement actions. They require a lot of work and investigation before they actually proceed with any suits.
For 12 years to collect. I mean, this is.
We gotta be,
look,
look, these are all policy calls. We gotta be careful, like how these absolute terms, because look, I mean, last year we passed a pretty big bill that got rid of statute of limitations, which Senator West frequently reminds us about. So that was a policy it was a big deal, but it was definitely a big thing that we did. And so just, yeah, I mean, it's a policy call. So you're making valid points, certainly. But just, we've all, it's not black and white.
Then open it up for everyone.
Yeah.
Not just the Attorney General. Add an amendment that anybody can go after somebody else.
I made the mistake here of waiting to be recognized by you, Mr. Chair. No, not you. I'm just saying, like, it's a good, I like those discussions, actually. But one of the questions is being answered already about the list of things, but listening to Senator West and then Senator Fulton, Senator Sidnor and Senator Charles, I was over here looking at different states and federal antitrust actions, and the feds, as you probably know, are 4 years. Other states generally go 4 to 5 years. I didn't locate any other state that goes to 12 years or no state at all that has no statute. And where there is an extension or a possible extension of a statute is where it's shown that there's an ongoing violation. And so, it doesn't end with the initial thing. So I just wanted to share that information. And of course, back to the overall subject of statute of limitations, I don't understand how we reconcile in our minds, hearts, and souls that we think this is worthy of such a lengthy statute of limitations, but we don't think that permanent brain damage of children through no fault of their own caused by predatory slumlords and paint companies doesn't warrant the same thing. I don't understand that. So if anybody would like to explain that to me, I'm waiting for the answer. I'll anxiously await for the answer. When we get into this business of eliminating statute of limitations, and I got into a lot of trouble about that bill that we passed last year because I fundamentally don't believe in it, but the pressure of doing something on the issue was too great to resist any longer. I wish we had that same sense of pressure and sentiment for these poor victims of lead poisoning that have permanent brain damage and are never able to realize their potential as human beings. So that being said, I actually think 12 years is still a little too long. That's my opinion.
All valid points. All right, Senator James, and then we're gonna go to Senator West and Senator Newsom.
Two issues. One, the 12 years. So somebody remind me, what it's about. The reason we even have a 12-year is in these odd cases of surety. What is it? Sureties? Something. You're allowed. We had this lengthy statute for 12 years in one narrow particular kind of case. What is it? And the reason I'm asking is, I know we picked it because of that, but I think there was a policy reason for the 12 years in that other case that has no analogy and no relevance to what we're looking at for the Attorney General. The second thing I was just so somebody please get back to me. The second thing, I am trying to quickly read the cases about the administrative proceedings versus court proceedings. And I think it would behoove us all to read this case, because I think the reason the courts have occasionally found no statute in administrative proceedings under whatever this is, 2-5-107 has to do with the nature of the case. And I would just like to be able to read this opinion and not do anything with this bill till I finish. Thank you. So nobody got back.
Thank you, Mr. Chair. So I find myself in,
She asked about the 12 years and nobody answered.
Yes.
She had a question and nobody was answering, nobody answered.
I don't think anybody.
Where did that come, what was the genesis of 12?
Yeah, nobody answered.
Senator West.
No, I know the case that allows for 12 years, Senator West, they're a very peculiar creature in Maryland. I forgot, right? And what I recall, and you could tell me I'm wrong, is the reason we do that and the policy behind it really has no application to these cases. Now, if I'm wrong, fine, but just if I'm right, then just remind the body that 12 years has a policy very peculiar to that kind of case. So we're borrowing that time, but not the policy behind it. So there really isn't any relationship. Just so people understand, we're picking the 12 years, even though it has no relationship to the case.
And Shamari, just for clarification too, like before we switch over to Senator West, then for those 12 years, that's generally things that are under seal, is that right?
Contracts,
Yeah.
contracts under seal is the only example the Attorney General gave, and I haven't seen.
And
any
that's
others.
because if they're under seal, they're what?
They're not open to
That's right.
inspection.
And more difficult to,
Yeah, of
that's what,
course, yeah.
all right,
That's right.
Senator West.
Not relevant here.
I wanted to respond to Senator Fulton's concern that we're opening up a massive door. Generally speaking, the Attorney General, this is unusual for me to be defending the Attorney Generals. So you'll have to bear with me a little bit. Generally speaking, the Attorney General does not have an awful lot of power to engage in litigation. His power, he's the attorney for the state. He represents all the agencies. He's on the defense side of litigation, but he tends not to have the power to initiate litigation unless we give it to him. And we give it to him through statutes. So, and what this says is a civil action for a statutory penalty brought by the Attorney General. So we have limited the cases in which the Attorney General can sue people and the statutory penalties are provided if he successfully brings those lawsuits. But they're in a very small category of cases, and only when the General Assembly is given the Attorney General the power to do it. So we're not talking about opening a door wide for any kind of litigation here. It's only in these narrow categories of cases. And yes, the Senator, come on. Senior moment here. The senator from Harford County is correct that this number was pulled out of the air because there are various the current Maryland code recognizes various lengths of statute of limitations, the highest one of which that I'm aware of is 12 years. So when I discussed with Mr. Sakamoto Wengel what we could do, I said, we got 3-year statutes, we've got 5-year statutes, we've got 10-year statutes, I believe in fraud cases, and we got 12-year statutes. And he just came back and said the Attorney General is willing to give up their effort to get an unlimited or to totally eliminate the statute of limitations, but is willing to accept a 12-year statute in its place. So the classic case of a compromise.
I'm pulling up the statutory section for actions that shall be filed within 12 years. It's 5-102 of courts and judicial proceedings, and they're called action on specialties, and they include a promissory note or other instrument under seal, bond except a public officer's bond, judgment, recognizance, contract under seal, or any other specialty.
And that was one of the questions, Mr. Chairman, that I had, and I think has been answered. I want to agree with the senator from Baltimore. 12 years is too long. Two things that have plagued us about Baltimore City since I've been here has been ground rent and lead paint. And we've done very little toward, dealing with those who are victims of this. I just think that we've got to send a message that when it comes to lead paint, we're trying to bring this whole issue to some kind of closure. And I think this is one of the ways to do it. And so I would say 3 years. I would say they've had enough, everyone's had enough time to deal with this. And I would agree that the fewer number of years, the better.
Is that a motion?
There you go. Yes.
By the time I get to me, I'm gonna lose my.
Yeah.
It's just real quick. Real quick, it's in response to Senator West, who has continually talked about what Maryland does in other situations. But my question was, and still not answered, what other state does this for this length of time for these kinds of actions? I don't believe any based on my cursory look. Can anyone answer that? Anyway, but I don't know if that's important because I go with the Muse 4-year.
Yes, sir, go, Senator Charles, go ahead.
Still want to get somewhat of an answer to this question. You know, as I was listening to Senator Carter talking about the ongoing piece, like if something's happening, I don't know if our Attorney General has done this yet, has brought civil suit to any of these paint companies. And, you know, we got obviously 50, 60 years of lead paint issues that's been impacting our communities. And he had all this time to grab, well, every single Attorney General has had nothing but time to pull information.
A long time making a lot of money in these cases. What, how long, Jill? Shit, sorry.
But look, to that point though, about the paint and also with banking. Yeah, Mr. Chair. So this is also to the banks as well. You know, the appraisal bias, you know, all types of issues that you know, the unfair lending practices by banks. Does this enough information for the AG to actually pull this and within a 12-year, less than 12-year? I think we pull this information in 4 years. You know, so I'm just willing to stand with Senator Carter and Senator Muse on that time period.
No, understood. All right, we'll revisit that when we come back. All right. We have to be on the floor in 4 minutes, so.
And Senator Foden.